The Constitution consists of 7 articles. Article 1 of the Constitution sets up the legislative branch of the federal government. It is the longest of the 7 articles due to the fact that the legislative branch is the most important and has the most constitutional authority of the 3 branches of the federal government. There are 10 sections in Article 1. We will go through each article individually and explain as we go.
Article 1, Section 1. All legislative powers herein granted shall be vested in a Congress of the United States, which shall consist of a Senate and a House of Representatives.
Legislative powers are the powers to make laws. A Congress is defined as a national legislative body or a formal meeting or meetings for discussions between delegates. In this case, delegates from the United States. The legislative branch is designed as a bicameral legislature, bicameral meaning having 2 branches, or chambers, consisting of the House of Representatives and the Senate. The U.S. Congress was partly modeled after British Parliament, which consists of a House of Commons and a House of Lords, and also partly modeled from the ancient republics of Athens, Rome, and Sparta. The power to make laws concerning the specific authorities given to the federal government by the Constitution is assigned to, or secured in the possession of, Congress.
Article 1, Section 2, Paragraph 1. The House of Representatives shall be composed of members chosen every 2nd year by the people of the several states, and the electors in each state shall have the qualifications requisite for electors of the most numerous branch of the state legislature.
The first paragraph of Section 2 holds a lot of importance. Let's dig in. Representatives of the people of the states will be chosen by election from the individual districts in each state every 2 years. According to James Madison in Federalist 52,
as it is essential to liberty that government in general should have a common interest with the people, so it is particularly essential that the branch of it under consideration should have an immediate dependence on and an intimate sympathy with the people. Frequent elections are unquestionably the only policy by which this dependence and sympathy can be effectually secured.
Since the representatives in the House of Representatives are the direct representatives of the people of their districts in each state, it is important that the connection of the people and their representatives remain close. The best way for that to happen is with frequent elections. In Federalist 37, Madison says,
the genius of Republican liberty seems to demand on one side, not only that all power should be derived from the people, but that those entrusted with it should be kept in independence on the people by a short duration of their appointments, and that even during this short period, the trust should be placed not in a few, but a number of hands.
Also in Federalist 52, he says,
it is a received and well-founded maxim that where no other circumstances affect the case, the greater the power is, the shorter ought to be its duration, and conversely, the smaller the power, the more safely may its duration be protracted.
In 53, he says,
biennial elections will be as useful to the affairs of the public as we have seen that they will be safe to the liberty of the people.
And then again in 52,
with less power, therefore, to abuse, the federal representatives can be less tempted on one side and will be doubly watched on the other.
As we continue in Article 1, we will see that the House of Representatives is given the most constitutional authority of any part of the federal government. It was the assertion of the framers that since it had the most authority, or power, that to balance that power, the terms of office for representatives should be shorter, and that would require more frequent elections. In the case of the House, that would be every 2 years. It is also the case that because the House has more power, it should have more members to spread that power out over a greater number of representatives. More power requires more representatives and shorter terms, doubly watched in order to avoid corruption. The Constitution was crafted with an intricate series of checks and balances such as this by the framers. Alexander Hamilton in Federalist 9 states,
the regular distribution of power into distinct departments, the introduction of legislative balances and checks, the institution of courts composed of judges holding their offices during good behavior, the representation of the people in the legislature by deputies of their own election. These are wholly new discoveries, or have made their principal progress towards perfection in modern times. They are means, and powerful means, by which the excellence of Republican government may be retained and its imperfections lessened or avoided.
The framers studied all previous forms of government to come up with a system that would work for the United States. They looked at the ancient governments of Rome, Greece, Sparta, and Crete, as well as contemporary systems in Europe such as England, Germany, Spain, and Switzerland. They determined what worked and what did not, and created an entirely new system based on the combined history of previous world governments. Madison, in Federalist 51, writes,
In framing a government which is to be administered by men over men, the great difficulty lies in this. You must first enable the government to control the governed, and in the next place, oblige it to control itself.
The framers were all too aware of the dark desires of men. All of these checks and balances were designed to curtail corruption in government. The Federalist Papers often referred to corruption and how the Constitution was crafted to stop it as much as possible. Madison in Federalist 62.
It is a misfortunate incident to Republican government, though in a less degree than to other governments, that those who administer it may forget their obligations to their constituents and prove unfaithful to their important trust.
Madison in Federalist 10.
Men of factious tempers, of local prejudices, or of sinister designs may, by intrigue, by corruption, or by other means, first obtain the suffrages and then betray the interests of the people.
They knew that there would be some who would run for office with ill intent, and once voted into office, betray those that elected them for their own personal gain at the expense of the people. History is replete with such behavior, and the framers structured the Constitution with every check and balance they could to stop, as best it could, corruption of those elected to office. There are many times in the Federalist Papers where Hamilton, Madison, and Jay address corruption in government. We will discuss these more and in more detail as we go through the Constitution. Electors were to be selected in each state for the purpose of electing the president, which we will discuss more in paragraph 3 as well as in Article 2. But these electors are to have the same qualifications as the members of the largest branch of each state legislature, typically a state House of Representatives.
Article 1, Section 2, Paragraph 2. No person shall be a representative who shall not have attained the age of 25 years, and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen.
In order to be qualified to be a representative, one must be at least 25 years old, be a U.S. citizen for at least 7 years, and live in the state from which one is elected. In Federalist 52, Madison says,
Under these reasonable limitations, the door of this part of the federal government is open to merit of every description, whether native or adoptive, whether young or old, and without regard to poverty or wealth, or to any particular profession of religious faith.
The House of Representatives is the most open part of the federal government to those wishing to serve. Natives, immigrants, rich, not rich, people from all walks of life, as long as they meet these very basic requirements.
Article 1, Section 2, Paragraph 3. Representatives and direct taxes shall be apportioned among the several states, which may be included within this Union, according to their respective numbers, which shall be determined by adding to the whole number of free persons, including those bound to service for a term of years, and excluding Indians not taxed, 3/5 of all other persons. The actual enumeration shall be made within 3 years after the first meeting of the Congress of the United States, and within every subsequent term of 10 years, in such manner as they shall by law direct. The number of representatives shall not exceed 1 for every 30,000, but each state shall have at least 1 representative. And until such enumeration shall be made, the states of New Hampshire shall be entitled to choose 3, Massachusetts 8, Rhode Island and Providence Plantations 1, Connecticut 5, New York 6, New Jersey 4, Pennsylvania 8, Delaware 1, Maryland 6, Virginia 10, North Carolina 5, South Carolina 5, and Georgia 3.
Paragraph 3 of Section 2 establishes a census that would be used to apportion representatives and direct taxes among the states. The first census was conducted in 1790 after ratification of the Constitution and every 10 years since. In Federalist 58, Madison writes,
With every successive term of 10 years, a census of inhabitants is to be repeated. The unequivocal objects of these regulations are, first, to readjust from time to time the apportionment of representatives to the number of inhabitants, under the single exception that each state shall have one representative at least. Secondly, to augment the number of representatives at the same periods, under the sole limitation that the whole number shall not exceed one for every 30,000 inhabitants.
In Federalist 54, he states,
The next view which I shall take of the House of Representatives relates to the apportionment of its members to the several states, which is to be determined by the same rules with that of direct taxes.
The purpose of the census is to count the number of people in each state. The population of each state determines how many representatives each state will have. States with larger populations have more representatives. States with smaller populations, less representatives, but each state will have at least one representative. State populations would also determine the apportionment of direct taxes on each state. We will discuss direct and indirect taxes in more detail when we get to Section 8 of Article 1, but for now, we will go into how it related to slavery at that time. This is rather intricate and complex, so please pay close attention. Slavery, existing pretty much since the dawn of man, is a vast, nearly endless topic. For the purposes of this study, we'll attempt to limit it to how it directly relates to the Constitution. In Part 1, Episode 1 of this series, we mentioned that slavery was introduced in the American colonies at Jamestown early in the 17th century. After that, slavery made its way to and was practiced in all 13 colonies. Eventually, slavery became practiced in 25 of the now 50 states before being eradicated. We also discussed early in this series how most of the colonies in the South were chartered for strictly economic purposes, while some in the North were chartered for not only economic purposes, but religious freedom as well. As such, some of these colonies, after becoming states, had outlawed the practice of slavery prior to the creation of the Constitution, and some shortly after. The first state to do so was Vermont in 1777 by way of their state constitution. Pennsylvania, founded by Quaker William Penn and named for him, was established on the principles of religious freedom and equal treatment of all people, including native tribes. As such, Pennsylvania instituted a gradual abolishment of slavery beginning in 1780. Rhode Island also instituted gradual emancipation beginning in 1783. In 1784, the state of Connecticut declared that all adult slaves would be free by the end of that year. In 1785, New York prohibited the sale and import of slaves and set a date of 1799 for full emancipation. New Jersey did the same in 1786. After a series of legal cases in the state courts during the 1780s, the Supreme Court of Massachusetts declared slavery to be illegal and ended it there as well in 1790. Because many of the states in the North had eradicated slavery or were in the process of doing so, a lot of people in those states weren't too happy with the idea of creating a new government with states that were still actively practicing it. This was a major issue in the creation of the Constitution. The states that had made progress in eradicating slavery wanted it abolished. The states still actively practicing slavery did not. They all, however, realized the importance and necessity of creating a new republic, so several compromises were reached in order to form the new union. The first of these was the 3/5 Compromise. As the census was designed to apportion representatives to each state based on population, the non-slavery states didn't want slaves counted as part of the population in the slavery states because those states could simply import more slaves and inflate their populations to get more representation in the House, which would give them more power. However, they did want them counted for the purposes of taxation. The slavery states didn't want the slaves counted because a larger population would incur more direct taxes from the new federal government, but they did want slaves to be counted for the purpose of representation. Ultimately, the question was whether slaves were to be considered and counted as people or property or both. Madison wrote fairly extensively about this in Federalist 54.
All this is admitted, it will perhaps be said. But does it follow from an admission of numbers for the measure of representation, or of slaves combined with free citizens as a ratio of taxation, that slaves ought to be included in the numerical rule of representation? Slaves are considered as property, not as persons. They ought therefore to be comprehended in estimates of taxation which are founded on property, and to be excluded from representation which is regulated by a census of persons. This is the objection, as I understand it, stated in its full force. I shall be equally candid in stating the reasoning which may be offered on the opposite side. We subscribe to the doctrine, might one of our Southern brethren observe, that representation relates more immediately to persons, and taxation more immediately to property, and we join in the application of this distinction to the case of our slaves. But we must deny the fact that slaves are considered merely as property, and in no respect whatever as persons. The true state of the case is that they partake of both these qualities, being considered by our laws in some respects as persons, and in other respects as property, in being compelled to labor not for himself, but for a master, in being vendible by one master to another master, and in being subject at all times to be restrained in his liberty and chastised in his body by the capricious will of another. The slave may appear to be degraded from the human rank, and classed with those irrational animals which fall under the legal denomination of property. In being protected, on the other hand, in his life and in his limbs, against the violence of all others, even the master of his labor and his liberty, and in being punishable himself for all violence committed against others, the slave is no less evidently regarded by the law as a member of the society, not as a part of the irrational creation, as a moral person, not as a mere article of property. The Federal Constitution, therefore, decides with great propriety on the case of our slaves, when it views them in the mixed character of persons and of property. This is in fact their true character. It is the character bestowed on them by the laws under which they live, and it will not be denied that these are the proper criterion. Because it is only under the pretext that the laws have transformed the Negroes into subject of property, that a place is disputed then in the computation of numbers. And it is admitted that if the laws were to restore the rights which have been taken away, the Negroes could no longer be refused an equal share of representation with the other inhabitants.
It was decided that slaves would be considered both people and property for the purposes of the census. Madison again in 54.
Let the compromising expedient of the Constitution be mutually adopted, which regards them as inhabitants, but as debased by servitude below the equal level of free inhabitants, which regards the slave as divested of 2/5 of the man.
And also in 54.
Government is instituted no less for protection of the property than of the persons of individuals. The one as well as the other, therefore, may be considered as represented by those who are charged with the government.
The compromise was that slaves would be counted as 3/5 of a person for the purposes of taking the census. This way, slave states couldn't gain additional seats in the House of Representatives, thereby gaining more power over non-slave states, and slaves would still be counted as people for the purposes of direct taxation, because they were people, not just property, which satisfied the concerns of all states at that time. The 3/5 compromise was intended as a temporary measure, with the eradication of slavery altogether being the ultimate goal, as we will see when we get to Section 9 of Article 1.
Article 1, Section 2, Paragraph 4. When vacancies happen in the representation from any state, the executive authority thereof shall issue writs of election to fill such vacancies.
If a seat in the House of Representatives is left open for any reason, for example by resignation or death, it is up to the governor of that state to call for a special election to fill the vacant seat.
Paragraph 5. The House of Representatives shall choose their Speaker and other officers, and shall have the sole power of impeachment.
The Speaker of the House is the presiding officer of the House of Representatives and is typically of the party in majority of the House and is chosen by the members of the House. Some of the responsibilities of the Speaker are controlling the legislative agenda of the House, managing debates on the floor of the House, appointing committee members, and being a liaison between the House, the Senate, and the President. Other officers in the House are typically chosen by the majority party as well. The House of Representatives is given sole power of impeachment by the Constitution. This is one of the crucial checks and balances in order to avoid corruption. As Madison states in Federalist 63,
"The people can never willfully betray their own interests, but they may possibly be betrayed by the representatives of the people."
and Hamilton in 65,
"The subjects of its jurisdiction are those offenses which proceed from the misconduct of public men, or, in other words, from the abuse or violation of some public trust."
If a public official has been found or accused of committing crimes or being guilty of serious misconduct, then it is up to the House of Representatives to impeach that official, which would be very much like a grand jury bringing an indictment against a citizen. Once charges are brought against a public official, a vote is taken in the House to determine if that person will stand trial in the Senate. The House has the sole responsibility of impeaching public officials, and it is a crucial power to be used to defeat corruption in the federal government.